Hey guys, in today's video, we are going to be taking a look at the second video on due process. So if you haven't watched due process part one, where I talk about the Fourth Amendment and a citizen's right to privacy, make sure you do that first. This video is going to be looking at specifically more of the rights of the accused, looking at the Fifth, Sixth, and Eighth Amendments. So our learning targets for this lesson are to summarize the protections of the Fifth, Sixth, and Eighth Amendments. And then these two are very similar to the last video. Explain how the Supreme Court has attempted to balance claims of individual freedom with laws and enforcement procedures that promote public order and safety. And explain the extent to which states are limited by due process from infringing on individual rights. Still looking at that framework that we are viewing this unit through. So just to recap, guys, right, due process are these procedures that prevent the government from unfairly depriving your right to life, liberty, or property. And specifically, we're making sure that the accused are treated fairly and according to the law. So we are really going to see that these rights that these amendments, that we're going to talk about, the Fifth, Sixth, and Eighth, provide for some pretrial rights that ensure liberties are not eclipsed by the need for social order and security in our justice system. And again, failure to comply with these usually results in an overturned conviction, right? We talked about in the last video, if a search is conducted haphazardly and is conducted quote unquote unreasonably, then the exclusionary rule takes place, right? Protecting people from that breach in procedure, right? That evidence could not be used in trial. So let's start with the Fifth Amendment. The Fifth Amendment outlines due process at the federal level. This was the very first time that we see due process in the Constitution, prior to it being incorporated into the states by the 14th Amendment. It also protects against double jeopardy. So this idea that if you are tried for a crime, you cannot be tried twice for that crime. Eminent domain is this idea that the government can take your private property for public use, but they have to provide just compensation. So an example of eminent domain in our city would be, if any of you are soccer fans, FC Cincinnati, they're building a stadium over in the West End. So what the local government did was they said to those local people, we are basically taking your houses, your apartments, and we are going to build a public stadium here. So therefore, that was a justified or constitutional taking of property. Okay. The Fifth Amendment also protects from entrapments and self-incrimination. And I've starred and bolded self-incrimination because this is what we're going to be focusing on from here on out. Now, the Fifth Amendment basically says that you cannot be compelled to be a witness against yourself, meaning you do not have to say anything that could incriminate you or make you look guilty. So I am assuming that most of us in here have heard you have the right to remain silent. Anything you say can and will be used against you in the court of law. Right? Obviously, there's more to that, and we'll talk about it in a second. But this is the Miranda rule, or the Miranda warning. And what this means is basically persons under arrest must be informed prior to police interrogation of their rights to remain silent, to prevent themselves from incrimination. And this came about because of the case of Miranda v. Arizona. And prior to this case, courts were handling a lot of caseloads addressing police coerced confessions, right, where the accused, I should say, were not informed of their rights, and police officers were coercing or forcing false confessions. And the question of this case really centered around, where does the right against self-incrimination begins? Or where does it begin? And the answer is once a suspect is in custody. because ultimately interrogation, once they're in custody, carries a badge of intimidation. So right from that initial moment of being under arrest, that person has the capability of the potential of self-incrimination. So you have to read the Miranda rights, or Miranda rule or warning as it's come to be called, to prevent that from happening. Okay, so the Miranda rule first talks about self-incrimination and the Fifth Amendment. Now, there is an exception to the Miranda rule, just as we saw there was an exception to the exclusionary rule of the Fourth Amendment, and that is the public safety exception. So let's say, for instance, that police officers are trying to arrest someone, and they are asking them about maybe where is a bomb, where is a gun. Okay, they would have to ask this first because this is trying to neutralize a dangerous situation and protect public safety. So ultimately, if they're required to get a statement before they are read, a suspect is read their Miranda warnings or read their rights, so to speak, that evidence can be admitted on the basis of that they were protecting public safety. So some examples. New York v. Quarles is a case that comes to mind. A man assaulted a woman and carried a gun into a grocery store. And then when he was searched, the officers found that his gun holster was empty. They ultimately had to ask where the gun was, and then he indicated where it was, but that was something that had to be done first to make sure that the police officers were safe. Right? If the police interrogate a suspect to determine the location of a bomb, obviously that is going to happen prior to the Miranda rights being read. So that is the public safety exception. Ultimately, this is a ruling that the states have the power to restrict some liberty for safety and order in this instance in particular. Okay, so moving on to the Sixth Amendment, I'm going to read you another statement that you are probably familiar with. If you cannot afford an attorney, one will be appointed for you. This is another part of the Miranda rule. So the Miranda rule encompasses the Fifth and the Sixth Amendments. The Sixth Amendment guarantees you a trial by jury of your peers, the right to counsel or a lawyer, a speedy and public trial. And I know some of you are like, speedy? It takes years for these things to happen. That's actually pretty speedy considering all of the cases that we have in our judicial system. And a confrontation clause. You have the right to know who is going to be a witness against you. Now, the Sixth Amendment right to counsel was not always really enforced, right? It was merely the right to have a lawyer present, and only because, without incorporation, this only applied to federal court. Okay. Now, Gideon versus Wainwright is one of our essential court cases that is going to incorporate rights to a lawyer to the states. All states must pay for a public defender when a defendant cannot afford one. So this is protecting the poor, the indigent, for example, and incorporating that Sixth Amendment right to the states via the Due Process Clause of the 14th Amendment. Now, one of the biggest issues that comes with this, if you cannot afford an attorney, one will be appointed for you. Look at this cartoon, right? You have the right to legal representation. If you cannot afford a lawyer, an inexperienced second-rate one will be appointed to you. Not all lawyers are equal. Just because you are appointed a lawyer doesn't necessarily mean that you will have the best representation. But the argument on the flip side would be some representation is better than no representation, or no counsel, for example. Okay, so Miranda rule encompasses both the Fifth Amendment, self-incrimination, you have the right to remain silent, and the Sixth Amendment right to counsel, having an attorney appointed for you if you cannot afford one. Okay, moving on to the Eighth Amendment. This is going to protect those accused of a crime against cruel and unusual punishments and excessive bail. And really, the controversy surrounding the Eighth Amendment deals mostly with capital punishment or the death penalty, and whether this is in violation of the constitutional liberty of the Eighth Amendment or not. Ultimately, In recent years, the Supreme Court has seen an increase in cases involving the death penalty. And this really hinges on the question of whether certain uses of capital punishment, as I mentioned, violate the protection against cruel and unusual. And the court's interpretation of what is cruel and unusual punishment has changed over time. In recent cases, as time has gone on, the court has prevented states from issuing the death penalty to defendants who are minors, whereas that wasn't always the case, or limiting it or preventing it on defendants who were legally judged to be mentally incompetent. So those with some sort of mental disability, the Eighth Amendment has been ruled to be cruel and unusual in those circumstances. Ultimately, we are going to take a look at the Eighth Amendment a little bit more in depth tomorrow. I'm going to have you guys listen to a podcast on the cruel and unusual aspect of the Eighth Amendment. So I don't want to go too much into it today, but just some things to know about capital punishment and the death penalty. This cannot be applied at random. The death penalty in the past was used for more crimes than it is today, but really it's reserved for murder cases, and the death penalty varies from state to state. So what you see on the map here, these red states have some sort of death penalty statute in them. But the death penalty can look very different depending on what state you are being tried in. Most states use lethal injection. However, some states, like Oklahoma, will still allow for other forms of execution, like firing squad, the electric chair. So it just kind of depends on what state you are being accused and tried in. Now, another key feature that we have to talk about are these civil liberties of the accused and national security, right? In times of war or international threat, our court has typically sided with governmental restrictions on liberties, right? Again, I'm talking about, Shank v. United States. We talked about in the last video that the ongoing debate about the extent to which government can monitor private data and communication while still preserving the liberties of citizens against their Fourth Amendment right to searches and seizures. And since 9/11, the U.S. has wrestled with this issue of protecting the nation from terrorism while also maintaining constitutional rights. So below here, I have four categories that really we have grappled with since 9/11 when it comes to terrorism, civil liberty, civil rights. So just thinking about it like this, right? Handling terrorists. Are these terrorists a group of people that should be sought out as criminals who violated federal law, U.S. federal law, under the established criminal justice system? Or should they be considered war against an outside adversary? Does the Bill of Rights even apply to these people, especially if they're being tried in U.S. territory, right? So do they have these protections that we've spent this entire unit so far talking about? Right? If we are going to treat them as though they violated federal law under the criminal justice system, right, that requires the federal government to follow standard criminal justice due process rights. Whereas on the other hand, if we view them as an outside adversary, there are fewer restrictions, but we do still have to recognize U.S. law and international treaties. So we do have some controversy surrounding what to do with the terrorists and their rights. Okay. Whoops. Sorry, guys. The war on terror is also something that has come under scrutiny here when balancing liberty and national security. Al-Qaeda and places like ISIS, or groups, I should say, like ISIS, are not really or technically a nation state. And thus, they don't really have to subscribe to the basic rules of war. Does the U.S. have to honor those provisions that it set out because of that? Does the Constitution apply to the United States' action beyond U.S. soil? So we're really looking at a lot of those questions when it comes to the war on terror. Since we're not fighting a country at this point, we're fighting an idea, a group of people. Guantanamo Bay and interrogations have also come up in this debate, right? Ultimately, if you don't know, Guantanamo Bay is a detention camp that we use to hold terrorist suspects. And it has come out that we use unconventional tactics that would be necessary to prevent another devastating attack, right? So there was something that came out a couple years ago called the torture memo under Bush, George W. Bush, where we were waterboarding suspected terrorists. Is this a violation of the Eighth Amendment? Should we be using these unconventional tactics? Are they absolutely necessary to prevent another devastating attack? Again, are we violating the liberties of those who are suspected terrorists? And then finally, the issue of habeas corpus. This is a part of our Constitution that guarantees that the government cannot arbitrarily imprison or detain someone without formal charges. So could detainees at Guantanamo Bay question their detention? Ultimately, the court says yes in a lot of cases. So we do have to think about how liberties and the balance between protecting them and our national security go hand in hand when we're combating these terrorist threats throughout the years. Right? So that concludes the notes for this section. In Google Classroom, underneath these notes, your job today is to start thinking about practicing an argumentative FRQ. So I have linked an article talking about civil liberties and whether they are being restricted in current times. I want you to use the notes from today, yesterday, and that article to formulate a claim to the question I have posed there, as well as find some evidence to support your answer. That is ultimately what you're going to be, doing for your argumentative essay on your, or FRQ on the AP test. So we're going to get some practice in there. So if you have any questions on the content of this note slide, if you want to drop by during office hours, send me an email. But otherwise, I will talk to you guys soon. Bye.